that we tried to invite somebody from the Attorney General office, but they're currently bound by privilege, so are not allowed to speak publicly. And we tried to invite somebody from the JAG, the Judge Advocate General, so the military legal service, and they, for different reasons, we're not quite sure why, but they first said that they would send someone and finally didn't send someone. So basically we tried everything we could, but didn't work out to get somebody from that side. I want to thank my ever-resourceful students, without whom nothing would be possible, and Haider also, and voilà. Welcome to all three of you. We look forward to hearing from you. Rashed.
Thank you very much. Welcome. Good morning. Is it afternoon? I'm not sure. Subject we're discussing today is contentious, to put it mildly. Has many ramifications. I will not dwell on them because my very eminent panel, I'm sure, will tiptoe you through the complexities. So without further ado, let me introduce the panel. On my right is Mr. Abid Saqi, who possesses a broad legal background and experience of more than 23 years as an eminent, successful, enchanting and committed lawyer in the legal fraternity. He's working as an advocate of the Supreme Court since the last 12 years, with specialized interest in constitutional matters, criminal, corporate, civil and media laws. At a very young age, having a vastly regarded name and a long list of reported cases, Mr. Saqi became an advocate in the Supreme Court on 30th November 2002. He's very well thought of amongst his fellow professionals. He has been a president of the Lahore High Court Bar Association in the year 2013-14. Previously, he had been representing the Lahore High Court Bar Association as secretary during the session 2000 to 2001. Not counting his considerable achievements and charismatic persona, and also highly cherished in the legal fraternity for being exceptionally knowledgeable and an intellectual person, fields of law, history, criminology, politics, socioeconomic studies, religion and literature. Go to the top of the class, On his right is Mr. Ali Sultan, the Executive Director of Research Society of International Law, an independent legal think tank committed to the promotion and enforcement of international law in Pakistan. He's been engaged in Pakistan's criminal justice sector reform for over 2 years, and his areas of research and scholarship include international humanitarian law, international human rights law, comparative criminal law, and comparative constitutional law. Mr. Sultan holds a bachelor's degree in economics and political science from Middlebury College and a Juris Doctor from the University of Virginia Law School, where he edited the Journal of Law and Politics. And on his right is Mr. Waqqas Mir. He's a partner at Mohsen Tayyab Ali and Company, practice that is based, headquartered in Karachi, but his firm's office is in Lahore. His practice focuses mainly on civil, corporate, and constitutional law litigation. His first degree is in economics from Government College Lahore, and he has a law degree from the University of London. He qualified as a barrister from Lincoln's Inn and has a master's degree from Harvard Law School, where he was a Fulbright scholar. He has also taught jurisprudence at LUMS in the past, and amongst his many other accomplishments, he writes a weekly column for the news on Sunday. Those of you who read it, sure, know that. As for me, in case you're wondering who the hell I am, I'm Rashed Rahman. I'm the editor of Daily Times, and I feel humbled to be moderating such an eminent panel, but I will try and do my best to not make a fool of myself. So I'll start off with Mr. Saqi. Abid, can you tell us this 21st Amendment, The manner in which it was adopted in rather a rushed manner. I've never known of a constitutional amendment to be accepted so fast. And as far as I'm aware, it is the amendment that has set up military courts. Now, can you very quickly and briefly first take us through what this amendment says, what it creates in the way of military courts, what is the jurisdiction of those courts, are they the be-all and end-all, or does appeal lie from them to a higher forum, higher court, and so on and so forth. I leave the rest. Abid Saqi.
Thank you very much, Rashed Rahman and all my friends. Primarily, the amendment was introduced by the military by bringing all political parties, so-called stakeholders, on gunpoint within the shortest possible time to carry out this amendment. And everybody consented to, without taking into consideration the ramifications, the repercussions, and the possible departure from the constitutional norms and the constitutional scheme which provides justice system or judicial judicature or justice system. So, in my humble view, this all is neither deliberated by the political forces, nor they conceived the ramifications of all this, but they have done all pursuant to the road master who is having, something in hand which was sufficient to demonstrate its path, and pursuant to that naked path, they complied with all the designs, intentions, and the motives of the military regime. I think there was, in bringing this amendment, there's no consensus by any independent political parties, but just they were brought together again, on a table, and then they were thumb-marked everything, and they decided to carry out the amendment. Amendment which was introduced in Article 175, which is the first article pertaining to the chapter of the judicature, whereby they have introduced the amendment that the existing judicial structure which is provided in Article 175, they have introduced amendment that there shall be the military courts under Article 175 to carry out the justice system which pertains to the terrorism or some specific offences which they will subsequently introduce through some other instrument, I think, because so far there is no methodology, no mechanism for putting in place these military courts. What would be the system? Who would be the presiding officers? Who would appeal from the accused side? Who will represent the case of the prosecution? So far, I am unable to know about these things, which are, I think, the basic ingredients to set up a court, even that is a military court. But no such thing is available to anyone so far. Everything is in the minds of the masters, how they proceed with the court system. Then they take that there is a parallel, there is the introduction of the tribunal and the subordinate judiciary or something else in Article 212, which says there is the court set up or the tribunal set up under Article 212 would have the exclusive jurisdiction to try certain matters, like service tribunals. Service tribunals deal with the service matters and all different tiers which we have introduced. They are protected under Article 212. Now they have incorporated the protection in Article 212 pertaining to military courts. But unfortunately, all this which has been done is a complete departure from the constitutional scheme, and the various judgments pronounced by the Honorable Supreme Court time and again enforcing the right of access to justice. Right of access to justice, when they started dilating upon these statements, so Asfandi Arwani's case, then Azizullah Memon's case, then Mehram Ali Shah's case, these 3, 4, 5 cases, in those all judgments, Supreme Court said that access to justice is a fundamental right which cannot be denied to anyone. Even the terrorists are also, I think, they are human beings. They are citizens of this country, and they are entitled to the same protection which is provided to all of the citizens. Who is murder of any ordinary offence or crime, he is also to be dealt with in accordance with law. Similarly, they are entitled to the same protection under the Constitution. These judgments have been, holding the field nowadays. But these judgments were pertaining to the executive orders whereby military courts were being established in the past by Nawaz Sharif or somewhere in that way. But this is the first time in the history of the country that military courts are being established through the amendment in the Constitution itself. No one wonders that whether by bringing an amendment into the Constitution can a complete departure from the constitutional dispensation is allowed by any of the reason or by any of the justification. So we are not clear as a nation, as a stakeholders, we are not clear. And simultaneously, the other question, whether the Parliament, being a sovereign institution, can have the powers to bring any amendment which they suit or they consider the right thing in order to meet the eventualities of the society. So there is a conflict between two streams of understanding and two streams of consciousness. One is that Constitution has to remain intact as it was conceived and promulgated by the founders or the parliamentarians, and subsequently no amendment deviating from the established principles of the Constitution is allowed. Second is Article 239 says that the Parliament is sovereign, they can bring into any amendment into the Constitution by following the procedure provided in the Constitution. And then no court is competent or entitled to interfere into the domain of the decision-making process of the Parliament. If they introduce any amendments, then courts are completely barred under Article 239. Article 239. No courts have the jurisdiction. Now the hodgepodge system of the judgments of the Supreme Court pertaining to various issues, they borrowed some basic structure theories and doctrines from Indian jurisdictions. In fact, they always borrow something from the other side. They never conceive anything by themselves, and they pose themselves as they are the prophets of the justice, and they are very high and above it. They cannot be, their integrity cannot be called in question. Their demeanor cannot, their standing cannot. This is their postures, the public face of the Pakistani judiciary. But in fact, unfortunately, they never ever, I being a law student, very humble law student, they never have originally formulated any question of, constitutional law in any judgment, instead of following some judgments of the Indian, and most of the time they follow the Indian law. So basic structure theory, which is being put into ears of the whole nation, is right. They have wanted borrowed from the Indian jurisdiction, and India, being jealous to their secular society, they try to consolidate the secular forces of the country by virtue of introducing the basic structure theory. Now, by following them, we have introduced Islam in place of secularism, and then federalism, and then access to justice, and then independence of judiciary, and all and democratic dispensation. And by formulating 3, 4, 5 points, we have introduced this doctrine of basic structure. India can, say that they have some basic structure in the Constitution, because their Constitution remains unadulterated, unpolluted so far, and only amendments are carried out by a procedure provided in the Constitution. There was no Ziaullah in India, there was no Musharraf in India, who have mutilated the entire Constitution, and they have introduced the amendments which suit their design, which suit their power perpetuation, and all that. And then they use the Islam as weapon to perpetuate their unholy powers in the country. So, as a constitutional student of Constitution, we have to see that we have failed to introduce or establish any particular constitutional wisdom by the Supreme Courts or the courts of the country, and nor any contribution is made by the political forces in this regard. So, as far as the 21st Amendment, my point of view is a conflicting point of view, I'm sorry to say. When I see the monster of terrorism was created by the army establishment itself in this country, they kept on, pampering them and producing them and creating them and feeding them for the couple of decades. this monsters become beyond their tolerant capacity and they have started sort of downsizing that. So let them do their job even if they establish the military courts. This is one point which remains, creeps in my mind some of the time. And then being a Democrat, being a citizen of the constitutional country, I think there cannot be this concept of the military courts while having the democratic dispensation in the country. So I am not clear about anything at this moment. And we can, have the clarity when we see that what mechanism and what procedure and what modus operandi they would introduce for function as a military courts. After that, we would be able to scrutinize that, examine that, appreciate that, and one way or the other के ये जो कैसे हो रहा है लोग सब क्या हो रहा है. और अगर इन्होंने if at all they have to introduce military courts for curbing the terrorism or dealing with the menace of the terrorism, then at least there shall be this another my personal point of view. Then there shall be a right of appeal to the Supreme Court even against the military court's decision. One right of appeal, so as to ensure that the minimum standard of justice is observed. Minimum, not maximum. But if the war doctrine allows the establishment of the military courts, some of our leaders and some of the senior lawyers say that this is a war situation arrangement, the introduction of the military courts is not normal state of affairs. That's why we have to accept this bitter pill for a couple of years, then so as to eradicate this menace. So even if this is so, then even then we have to know the rationale, wisdom, the procedure, तरीकाकार क्या होगा, कैसे करेंगे. एक military major sitting somewhere without having any evidence and on his own, on the basis of his own subjectivity or revelation, which something reveals upon the military officers of this country, some way or the other. So they can hang someone, they can direct execution of someone. So it would be unfair, it would be unjust, it would be, barbaric. So there shall be one right of appeal to the convict by the military courts to the Supreme Court, so as to ensure the transparency and minimum standard of justice. This is my point. Thank you very much, sir.
As I expected, Abid Saqi has touched on a number of issues. I won't rephrase them, I'll simply mention them as we go along before we go to our next speaker. I think the first and very important point is made is that so far we are in the dark. What are going to be the rules and procedures governing these military courts? And this is doubly alarming because we are now standing literally on the eve of the start of their functioning. And today's papers are reporting that, some military courts are going to start functioning. That must be GHQ. Some military courts are going to start functioning very soon. So it is a matter of concern how they are going to proceed. You see, there are a lot of... It is something else. There are a lot of concerns about the inherent nature of the process in military courts. That compared with civil courts, it tends to be rather more arbitrary and summary. And whether the proper right of defense and fair trial, which I believe now under the 18th Amendment, Article 10 has reiterated, 10A has reiterated. Then of course he's touched on a very fundamental issue, which is, there's a great controversy about this, different points of view, whether there is actually a basic structure of our Constitution, and if so, whether it is violated by this 21st Amendment. There is no legal challenge to that yet. There may well be, I don't know, but we shall have to wait and see. But what I would like our next speaker to dilate on, Mr. Ali Sultan, is to put for us in context what was the felt need or rationale or necessity for plunging into the creation of military courts literally overnight and without a forethought, or proper discussion.
Okay. Can I do my presentation, my PowerPoint presentation?
Yes, yes.
I'm going to try to address your question and some other issues that
Is your mic working?
like to touch on as well.
There should be a light on.
There is. Can everyone hear me? Yeah.
How do I do slideshow?
Green light or the red? I'm fine.
So then turn on the light.
Red lights have never bothered us. We go through them all the time. Okay.
Okay, can everyone hear me? So what I've tried to do is I've just tried to put together a presentation for about 10-15 minutes to touch upon some of the issues that we've already spoken about, but maybe in some greater detail that I'd like to address in this presentation. Can we go on the next slide? How is it going?
Yeah.
Somebody needs to operate this.
Okay, so what is the 21st Constitutional Amendment? We've already touched upon this.
Yes, yes, yes.
We have already touched upon this, but I think we would immensely benefit if we also focus on the exact wording of what this amendment is saying, which is why I want some of that language on this slide. So it's an amendment which is passed by the Parliament through a procedure which would be deemed legitimate, and it was done in the aftermath of the blood-curdling. This is Barack Obama, I borrowed it from him, blood-curdling attack on the Army Public School Peshawar to establish military courts. Why? For a speedy trial of those suspected of waging war against the state. This is the language from the preliminary of the Amendment Act. Speedy trial is one concern that they wanted to address through these courts. And how have they tried to do it? They've brought amendments in Article 175. Saqi Sahab already touched upon it. It deals with the establishment and jurisdiction of courts. But the language is interesting. It exempts trial of those who claims or is known to belong to any terrorist group or organization using the name of religion or a sect. This subsequently became controversial as well, especially by JUIF. But notice, so you cannot have a political motive. That the amendment is not addressing cases where terrorism would be motivated for political purposes. For example, in Karachi. Karachi would be an example. Balochistan could be an example as well. The second thing that they did was that they added a few statutes, including the Protection of Pakistan Act, the Pakistan Army Act, the Navy Act, and the Air Force Act, into the first schedule of the Constitution. What is this first schedule? This exempts laws for consistency with fundamental rights. So this is how they've tried to...
Does that mean that these are laws that can be amended without reference to fundamental rights?
Essentially, yes. They do not necessarily have to conform to fundamental rights. And they cannot be challenged for lack of consistency with fundamental rights. Right? Now, the next thing is that it's important to remember that it has a 2-year sunset clause, and it's going to lapse in January 7th, 2017. So one way of looking at this, which I'll come to in the end, is to see it as a stopgap measure, and in the meantime, your civilian criminal justice system, you can inject much needed reforms to it. Can you go to the next slide? Now, they've not just only amended the Constitution, but they've also amended the Pakistan Army Act. Okay, and just to answer your question, that the procedures that are going to guide these courts are listed in the Pakistan Army Act and the Pakistan Army Rules, 1954, 1952, and 1954. Now, whether those procedures, those safeguards, whether they conform to international standards or not is a separate matter. That needs to be, somebody needs to assess that. This has not yet been assessed. I'll come to that later as well. But this is important. So the Army Act is now going to apply. Now typically Army Act is meant for military personnel, disciplinary matters. It makes sense, right? But here there are civilians and persons who are claiming or are known to belong to any terrorist group or organization using the name of religion or a sect, they replicate the language from the amendment. So you need to belong. That's one associational element attached with it. You have to belong to a terrorist organization which is using the name of religion or a sect.
What about lone wolf terrorists?
No, under this they would not be subject to this. I think
I don't want to give anyone any ideas.
the language is very clear. So a Ted Kaczynski, a bomber or someone like that is not going to fall prey to this. So you need to belong to an organization and then you need to do something in addition to that. So you need to satisfy both these elements. It's very important. What is that? You raise arms or wage war against Pakistan, or attack the armed forces of Pakistan or law enforcement agencies, or attack any civil or military installations in Pakistan, or abduct any person for ransom, or cause death of any person or injury, or possess, store, fabricate, or transport the explosives, firearms, instruments, articles, suicide jackets, or use or design vehicles for terrorist acts, or provide or receive funding from any foreign or local source for the illegal activities under this clause, or act to overawe the state or any section of the public or sect or religious minority, or create terror or insecurity in Pakistan, or attempt to commit any of the said acts within or outside Pakistan. Now, in addition to this, there's also accomplice liability and there's also conspiracy based liability, which I chose not to include here, but it's also part of the amendment.
Ask a question?
Please.
The wording which says any of the said acts within or outside Pakistan.
Yeah.
Well, that's a very interesting formulation for me, because on the one hand, this is waging war against Pakistan or its armed forces or whatever. Why would anyone be waging war against Pakistan or the armed forces of Pakistan outside Pakistan?
Perhaps from Afghanistan, maybe. That could be a concern, I suppose, right? But this is the wording. And if you go over the wording, we can subsequently assess whether it's vague, whether it's broad in scope or not. I mean, those are issues that we really need to discuss further. Can I go to the next slide? Okay, this is a bit of a figure, there's always a balancing act between order and liberty. That's always been the case. This is divided political and legal scholars. And just to give you an example, Abraham Lincoln, when he wanted order, he instituted military commissions during Civil War as well. But later on, he perhaps contributed to greatly to the cause of human liberty through his Emancipation Proclamation. So you see the conflict right there. So perhaps this is something that we need to keep in mind as we further assess this issue. This balancing act, I'll admit it's kind of a bit of like a search for the philosopher's stone or something. It's hard to find this balance, and it's usually judgment call where you stand on this issue, on this balance. Can I go to the next slide? Okay, so let's just assess now that we've looked at the language a little bit. The first issue that we need to ask ourselves, are these codes a necessary and a proportionate measure in the face of a collapsing, sclerotic civilian criminal justice system? And it is collapsing. It is sclerotic. It's resistant to change. There's a lot of inertia in it. If you want to change it, it's probably a generational issue. It's not something that you can fix with a silver bullet. I've been looking at studies identifying issues with anti-terrorism codes, with your criminal justice system, going back last 15 years, and some very good studies. And those issues are still prevalent. So, does that mean that maybe, as Saqi was also alluding, that one stream of thought would be that perhaps because your criminal justice system is so rotten and it's collapsing, and there's no hope to reform it, to respond to the challenge that we are facing, perhaps this is a necessary and a proportionate measure. Proportionate proportionate to the threat that you face, specifically by the Tehreek-e-Taliban Pakistan. The second issue then is it vaguely worded? When you were looking at the language, when you were reading the language, was it clear enough to you? Was there vagueness? I think there is a bit of a vagueness in it. My phone.
No, I think it might be earphones, no? Turn them on.
Mic open.
Turn off the mic, but you don't want to.
Yeah. Now the second issue then is it vaguely worded? Is it clear enough? I think you can make a good case that perhaps the formulation could have been much better than what they ended up with. And one reason for that perhaps is that this was done in a lot of haste. And whenever you do things in haste, you can't really get the best result. The third issue is it overly broad in scope? Now if you go back to the language, I think it's quite broad in scope. That's not a good thing. If you wanted such a measure, which was necessary and proportionate, you wanted to restrict it in its scope, right? And that's the problem that we have had in our other anti-terrorism legislation as well. That's the problem we have had in the ATA. The Section 7 is too broad. It's vaguely worded as well. That has led to its abuse over the years. The same language issue we have in the Protection of Pakistan Act as well. And it seems like the government really needs a much better draftsman than they do right now. Because what they've done is that they've made the same mistake again. So if your aim is to speedily try certain specialized offences against the state, then you do not want to clutter the system. But if your wording allows you to expansively interpret it and clutter it, that defeats the purpose of establishing them in the first place. So that's why it's very important that it should be interpreted in a very narrow sense, even if it's allowing very broad ambit. The fourth issue, again, this is also part of the amendment, but I didn't put it up on this slide because that would be too much to read. Retrospective application. Now the cases which are already going on in the ATC courts, for instance, the amendment makes it clear that the federal government, if it wants to, can refer those cases to these military courts. Now that's the problem with retrospectivity. That cannot be squared with modern legal principles that you have to satisfy for due process, for instance. Although I will tell you that at the international plane, in the Nuremberg trials, they did accept the retrospectivity principle. But that's probably an exception, and we should see it as an exception. So the second thing that I would like to say is that even if the amendment allows for a retrospective application, I would still advise the government not to do this. Because that's going to lead to a loss of legitimacy for these courts, internationally as well as domestically. That's very important. It's extremely important. So abstain from this as well, abstain from retrospective application as well. Okay, can I go to the next slide? Now, I had to say something about the pending challenge to this amendment before the Supreme Court, and Saqi sir touched upon this as well. Now, I am legally trained to be a strict constructionist or a literalist when I am interpreting a constitution. Okay? So for me, I have no confusion that the Constitution grants absolute right to the Parliament to amend the Constitution whatever way it wants to, because they represent the democratic will of the country. And if the amendment is something that the nation has issues with, there's always political accountability in a democratic system. There's a built-in electoral accountability in a political system which does not exist in a judicial system, least of all ours. Our judges have this huge democratic deficit when it comes to our judiciary in their appointment process. In the US, for example, the president nominates and the Senate has to confirm, and there have been nominees who have been rejected by the Senate. So even in that system, where there's still a lot of democratic deficit, you would still want a strict instruction. And what does the Article 239 say? No amendment of the Constitution shall be called in question in any court on any ground whatsoever. For me, this settles the issue. So this is a frivolous challenge before the Supreme Court. I don't even want to go beyond this. I don't even want to consider anything beyond these words. I'm not supposed to as a lawyer. If I do, I'm just making stuff up. Okay? So somehow, that's my sort of legal interpretation. Of course, someone else can give me a different interpretation as well, which I will of course dispute. And that's why we're lawyers, because we have to disagree. The second thing, basic structure doctrine. This is the ground on which this amendment will be struck down, if it is struck down at all. It has an uncertain place in desirability. I would say it has no desirability because you cannot reconcile it with the democratic principle. You just cannot reconcile it. It just adds a lot of potpourri to the whole thing. The place is uncertain. Until 2005-2006, it was pretty certain that our Supreme Court did not even recognize this doctrine. But then Iftikhar Chaudhry's Supreme Court, which was a court on steroids, and ran carts and horses through various constitutional and jurisprudential principles. Now when the 18th Amendment came before the court, in obiter dicta, the courts did recognize the existence of this doctrine in our system. So they have recognized that there is such a thing as basic structure doctrine. But its exact contours are unknown, which is why this current case is of extreme significance. Because it's going to settle this debate as well. Do we have a basic structure doctrine? If we do, what are its exact contours? Saqi have already alluded to this. Islamic provisions. If there are Islamic provisions which we deem to be the basic structure of the doctrine, which can never be changed, that means that if our generation, maybe the next generation, can never secularize this country if they want to. Right? What about the federal principles? That means we can never have a centralized presidential form of government. That's another debate we need to have in this country. So for me, this is poisonous. This is a toxic way of thinking. Basic structure. I do not support it. I cannot support this. Okay? So, as far as I'm concerned, because the Parliament has decided through a correct procedure, at least apparently so, these amendments have to stay for the next 2 years. And what we need to decide now is how to make best use of this time and these courts that we have set up. How do we organize them? How do we ensure that there's legitimacy, some legitimacy attached with them, and also that they are operating within certain bounds of law and due process. That, I think, is the main issue now. Can I go to the next slide, please? Can we go to the next slide? Thanks. Now, this, towards the end of this conversation, Mr. Saqi alluded to the fact that some people are saying that since there's war in Pakistan, these forums, the military courts, are natural sort of forums for trying war crimes. Okay? Let's explore that argument a little bit. The first thing, this is from an international law perspective, strictly. Is there a non-international armed conflict in Pakistan? Now, over the years, the notion of armed conflict has grown to cover not just international armed conflict. India-Pakistan is an international armed conflict, but also non-international armed conflict. So Al-Qaeda versus the USA is a non-international armed conflict. Similarly, can we say, or can we explore the possibility that there is a non-international armed conflict in Pakistan between the state and the Tehreek-e-Taliban Pakistan and its affiliates. Now there are certain elements that we then need to examine to be able to answer this question. Now these are from an International Criminal Court case, Tajik, which is where these elements and these standards are coming from. Again, we've got to keep in mind that this is an emerging area of the law. 10 years ago, nobody was talking about this. Before 9/11, nobody was talking about this. So there is, I mean, there were people talking about this, but there wasn't a lot of interest beyond IHL specialists in this. Anyway, so what are some of the elements? And let's just ask ourselves, are these elements fulfilled or satisfied when it comes to Tehreek-e-Taliban Pakistan or not? The first is the number, duration and intensity of individual confrontations. We have been in this confrontation for almost a decade now, more than a decade now. So certainly yes, you would fulfill this. The type of weapons and other military equipment used, the sophistication. Well, their weaponry is more sophisticated than the weaponry, some of the weaponry that our law enforcement agencies have. So this is a yes as well. The number of casualties. Figures are anywhere from 50,000 to 60,000 civilian deaths and 5,000 to 10,000 government personnel and military personnel deaths. That's huge. We have lost more generals in this war than we ever did, than we have in our wars with India, for example. We have lost more police officers than in any other conflict. The extent of material destruction, again, this is self-explanatory. The number of civilians fleeing combat zones, IDP crisis, we've had several of those. So this is fulfilled as well. Protracted armed confrontations, yes, it is protracted as well. So the first prong, which is the intensity, I think is fulfilled in this case, right? Then we go to the next slide. The second prong is organization. Whose organization am I talking about? Not the state. The state, obviously, it's assumed that the state is going to be organized, which is why it's a state. I'm talking about the organization of the Tehreek-e-Taliban and their affiliates. Who are their affiliates? These anywhere groups from 22 to 25 who are affiliated with them. And these affiliations are well known and they're proudly affiliated with them. So organization, the existence of a command structure within an armed group. Of course, there is a command structure. That's why we keep hearing about Fazlullah, for example, right? There is a strict hierarchy within these factions, as well as the TTP. The group's ability to plan, coordinate, and carry out its armed activities, of course. They've got remarkable abilities to plan, coordinate, and carry out their activities. Their ability to negotiate and conclude agreements. How many peace agreements have we tried to negotiate with them in the past? Of course, they had the capacity to negotiate these agreements in the first place when those agreements were concluded, right? So again, yes. Ability to gain recruits. Are they gaining recruits? Can they gain recruits if they want to? Sure, yes. Its ability to procure, transport, and distribute arms. Again, there's an entire weapon distribution network that they have. So again, I would submit to you that even these elements are satisfied. And when both the prongs, intensity as well organization, is satisfied in this case, then perhaps we should think of this as not an ordinary law and order situation, or not an ordinary terrorism situation that we can deal with our established anti-terrorist courts, but we should deal with it, but we should think of this in terms of a non-international armed conflict paradigm, and then assess the relevant standards which are applicable to non-international armed conflict. That's one way of moving ahead and thinking about this issue. Can we go to the next slide? Now, if we accept the proposition that there is a non-international armed conflict in Pakistan, then what we can say is that this is what Tehreek-e-Taliban is really breaching. It's very clearly laid down as a war crime in the International Criminal Court statute, the Rome statute, in Article 8. Article 80, intentionally, if you do this, you're committing a war crime. And if you're committing a war crime, war crimes can be tried by military tribunals. Right? So what is this? Intentionally directing attacks against the civilian population as such, or against individual civilians not taking direct part in hostilities. So you cannot target civilians. Even in war, there are well-established, long-standing international humanitarian rules which clearly prohibit civilian. In fact, the whole purpose of IHL is to distinguish between civilians and combatants, so that you can't target civilians. So if the Tehreek-e-Taliban Pakistan in a non-international armed conflict is intentionally and deliberately and brazenly targeting civilians, which they have been, way before Peshawar and since Peshawar as well, then you can think of them as having committed a war crime. That's again, I don't want to be conclusive about this. I'm just suggesting ways in which you can think about this issue. Can we go to the next slide? Now, what is the way forward as I see it? Again, like I said, I accept the fact that these courts have been constituted as a reality now. I'm not going to assume that they will be struck down through this challenge in the Supreme Court. So what should we do? Well, first of all, as I've already said, very few and genuine cases. Now, what are genuine cases? Perhaps those involving Tehreek-e-Taliban Pakistan and its affiliates only. Keep it restricted. Just restrict yourself, as far as these courts are concerned, to Tehreek-e-Taliban Pakistan and their affiliates. Sure, perhaps at some point, as Saqi Sahab was saying, there were forces in this country which created them, which nurtured them, and ideally they should not have done it. But now, if there is perhaps some newfound resolve to go after these elements, maybe we should give the state or those authorities the tools that they need for the next 2 years and see where things go. They can't go any wrong than they already are in Pakistan, as far as the criminal justice system is concerned, right? So let's just give them the benefit of the doubt, I suppose, and ensure that very few and genuine cases should be referred to the military courts, with the federal government formulating a restrictive jurisdictional and admissibility criteria for the service. This is something which the government needs to do. There should be people in the Ministry of Law and Justice working on this, beavering away at this right now. Unfortunately, they're not. But they should be. Or they should, The second thing that needs to be done, again, as I already alluded, the Pakistan Army Act 1952 and the Pakistan Army Rules of 1954, they already contain procedures. There's already been talk about appellate procedure for these courts. It's all listed in the Army Act and in the Army Rules of 1954. Quite elaborately, actually. But there needs to be a due diligence review for compliance with international standards for military courts, which come from Geneva Convention, for example, Common Article 3. It has certain requirements, as well as there are well-established principles which have been issued by some other international bodies as well. So the government needs to review this, and changes where and if needed be made to ensure that they comply with international standards for military courts. They may not be the same. In fact, they are not the same standards as you see for civilian courts. They're not. The third thing is that there needs to be a robust administrative oversight mechanism that should be instituted by the federal government for these courts. You can have some retired judges overseeing this. You can have a rapporteur. You can have an ombudsperson. There are various. There is a range of options which the government can exercise in this matter, but they need to do this. This is important. The fourth thing, the military courts should be strictly viewed as a stopgap measure. This is important. At least bad option. It's not an ideal option. It's not. But it's probably at least bad option at this point, in the prevalent circumstances. And they should, in the next 2 years, spur rather than detract from much needed wholesale reform of the civilian criminal justice system. So think of it as a strictly short-term measure, and it should spur on reform of the civilian criminal justice. So it's ready in the next 2 years. Can we go to the next slide? Why is it important that it's short-term? I had to throw this in. Benjamin Franklin, one of the American founding fathers, those who forever surrender freedom for security will not have, nor do they deserve either one. So we need to keep this in mind. Thank you.
Well, I'm sure that was an excellent presentation, and I think it's clarified a number of issues. But I want to raise one or two points quickly before I call on our next speaker. I asked the question when we began about the need, rationale, context. I think you explained some of it, but I think there is something still to be dealt with. And that, I believe, is the argument that the criminal justice system as a whole and the anti-terrorism courts in particular, which were meant to deal with these issues, have failed. How have they failed? How do we define that failure? Well, the whole idea of anti-terrorism courts, as I understand it, was quick disposal of cases. And the rules, if I'm not mistaken, say day-to-day hearings. And yet, over these years, since the anti-terrorism courts were established, we haven't seen a great number of convictions. We haven't seen disposal of cases rapid. And so, this failure, I think, to meet the requirement for which these courts were set up has strengthened the argument of doing something immediate and perhaps precipitate. Very interesting point you made about constitutional amendments being unchallengeable legally because of Article 2395 that you quoted. I would like someone, maybe Waqqas can do it, to inform us, because as far as this, constitutional constructs and particularly basic structure arguments are concerned, there is no one-size-fits-all. You have a British Parliament which has no written constitution and is, the received wisdom says, able to declare a man a woman if it wishes. There's absolutely no restraint on its power. And on the other hand, you have the United States, you have France, many other countries that have written constitutions, and therefore the implication at least is that those constitutions are based on some basic fundamental principles. And that is basic construct, and that is, an interesting debate whether in Pakistan, as you said, as you asked, we have such a construct, and if so, has it been properly defined so that it can form a benchmark against which we can measure things? I'm not clear about it. I'm not a constitutional expert, but I think this whole issue, two issues that you raised, Islamic provisions, federal principle. Some things seem to be basic, and a lot of areas are undefined, it seems to me. I could be wrong. But I think in the context of the 21st Amendment, this is where we began from, I think we must view it in the context of what happened in the Army Public School in Peshawar. Clearly, this was an army-run institution. A lot of the children who were killed there, studying there, killed there, were army kids. I, grieve for them as much as anyone else. But it does trouble me that it took an attack on an army-run school. Admittedly, it was a horrible massacre, a huge massacre, and so on. But have children not been dying because of terrorism in Pakistan before that? Are they children of a lesser God? I don't know. I mean, this sudden sort of, turnaround, a quick passing of an amendment and setting up a military courts, it troubles me that, this crisis has evoked a far greater and quicker response than anything we've seen in the past. And I suspect behind this is what we like to refer to as the civil-military imbalance in Pakistan. The military can get its way when it wants. And it seems to me that in the case of the political class, the tears of Raza Rabbani in the Senate notwithstanding, we don't seem to have the courage of our conviction. I would have liked to see a few resignations if people were that troubled by passing this amendment. But the party whip worked, and I suppose the bigger whip worked, so that's the end of that. I want to just say at the end, I'm going on too long. You spoke of the TTP and its affiliates. I think one very important element of those affiliates is the sectarian groups. They may not be attacking the military, they may not be attacking the state, they may not be attacking state institutions. They are certainly attacking citizens of a different sect or denomination. I only have to mention the Shia. There's a slow genocide been going on for decades in this country, and it's accelerating, if anything. So I hope that this provision covers sectarian terrorism as well. I won't say any more. I'll call our next speaker, Mr. Waqqas Mir, who is a constitutional and legal whiz-kid, I'm told. Let's hear what he has to say.
Thank you, Rashed Rahman, and I'd like to thank Christine and everybody for being here. I'm grateful to my co-panelists for the things they said. I'm particularly privileged to be here in Rashed Saab's company. I mean, his father, Justice Rashed Rahman, is one of the great legal giants that we've produced, and I'm particularly inspired by him reading his judgments. So I'll try and quickly talk about what the basic structure doctrine is, and then I'd identified 4 or 5 points which I wanted to rush through, with people here. And I'll take about 15 minutes. Is everybody here a law student, or are most people here normal people? Not normal.
Are there any lawless students?
Okay, so the basic structure doctrine basically says that, in essence, that the Constitution as a document has certain essential immutable features which cannot be amended. Sorry, is it okay if I stand?
Yeah.
So, the basic structure doctrine basically says that the Constitution as a document has certain immutable, unamendable features. And if you try and amend them, the court that has the jurisdiction to review executive or legislative action can strike down that constitutional amendment, right? So normally what you do is if there's an ordinary law of parliament, you can challenge it before the High Court or the Supreme Court in Pakistan. But traditionally, you can't challenge a constitutional amendment before the High Court or the Supreme Court, because you normally test whether a law is constitutional or not by comparing it with the Constitution, right? So the argument is if the Parliament amends the Constitution itself, then you can't strike it down. The basic structure doctrine is actually borrowed from India by countries such as Bangladesh, but it is actually rooted in the German Constitution. After World War II, Germany had a serious problem, and it recognized that because of its history, because of what Hitler did and all the atrocities that he committed, they needed to build certain things into the Constitution, and those certain things could never be amended, right? Because Hitler taught us that you could come to power with popular vote, and then you could do truly horrible things to your people and to other people, right? So Germany decided to write that down into the Constitution, that we have certain things which can never be amended. So dignity of man, so on and so forth, being one of them. And later on, if you want to get into the development of that, they've struck down abortion-related laws on that touchstone. What India did in the 1970s in the Keshwananda Bharati judgment was that it accepted the basic structure doctrine. It was the first country that accepted the basic structure doctrine after Germany. What India did was remarkable, not because they were following the basic structure doctrine, but they were following the basic structure doctrine even though the Indian Constitution never said that certain things cannot be amended, right? So that means that the judges came up with that power, right? So in Germany, they wrote it down in the Constitution, you can't change this, and if you do it, it will be illegal. In India, they never wrote it down in the Constitution, but the judges did not like specific constitutional amendments, so they said the Constitution has a basic structure, and if you try and mess with it, it's illegal. Right? How do you define the basic structure? You only have to see the Keshwananda Bharati judgment for that. I think it's a 7-6 dissent, 7 judges voting for striking down the constitutional amendment and 6 voting against it, and all 7 have their own conception of the basic structure. Right? So it's 7 unelected men, largely from a middle-class heterosexual background, and they're telling the rest of the country what the basic structure of the Constitution is. There are no women, there was Justice Ray, I think so, 1 or 2 people from the minorities, but not the entire cross-section of society represented.
Sorry, because can I quickly ask?
Yeah.
are they saying that there are implied basic concerns?
Yeah. So you gather. I'm glad you brought that up. Thank you. So you gather the basic structure by reading the Constitution as a holistic document, and you don't necessarily have to locate the basic structure in any particular line or provision. You can read 4 or 5 provisions together and say, aha, the basic structure that emerges from this is actually this. Right? So there are judges who said that this hangs over and above the Constitution. Right? So what does that mean? I've never been able to understand that till today. Now, we've never accepted the basic structure doctrine in our country. Right? At least we've never used it to strike down a constitutional amendment. Right? The word that the Pakistani Supreme Court has used from the 1990s onwards is basic features of the Constitution. Right? But in a number of judgments from 1998 onwards, Waqqas Mir's judgment and a few others, there are 2 or 3 judges who use the word basic structure, but they were never able to get majority votes. Right? So there are judgments even before the Chaudhry Court that will talk about the basic structure of the Constitution, but they've never used it as a doctrine to strike down a constitutional amendment. Right? So I hope that tells you something about what the basic structure doctrine can do. If the 21st Amendment is struck down, it will be an enormously important moment in our history, because that will be the first time the Supreme Court actually strikes down an amendment to the Constitution. And as my co-panelist said, it will be problematic because it is essentially anti-democratic. If people have voted for something, for whatever motivation, if they voted for something, Parliament has written that down as the law of the land, and if 15, 17, 12, whatever the number of judges decide to hear the case, if they strike it down, some people can have a problem. There are other people who will defend the basic structure doctrine by saying you need something like this in nascent democracies. And people will make the argument that if you had a basic structure doctrine, then you wouldn't have allowed the Ziaul Haq or Parvez Musharraf to mutilate your constitution. Okay, so there is a counter argument as well. Now, which side do you want to fall on? That's for you to decide. I'm just trying to paint both sides of the picture, because I've taught in this school, so I'm still trying to be an instructor again, once I'm addressing an audience. So it's up to you, whatever you want to decide. But these are the 2 arguments. Now I'll address 4 points in about the 10 minutes. Can I take that? In about the 10 minutes that I have. Right? So 4 or 5 questions that I want to discuss with you, and it doesn't matter that you're not law students, you're citizens of the country. So, and even if you're not a citizen, even if you're here from elsewhere. So I see some people not from Pakistan. So these are things that concern every citizen wherever you live. Right? So what is the first question is, what does the 21st Amendment tell us about laws and constitutions in general? Right? Then I'll talk very briefly about the Nuremberg trials and the analogy that was just drawn. Then I'll talk very briefly about why did we need military courts in the first place. And I'll try and touch upon how they work and where do we see ourselves going into the future. So the first question is, what does the 21st Amendment tell us about laws and constitutions? It's fascinating to me to observe people's reactions to this, because people use the word constitutional to mean not just something that is legal, but also in a moral sense. Right? So if you see something terrible happening, you say, isn't that unconstitutional? That has to be unconstitutional. 21st Amendment challenges that. It builds something horrible into the Constitution and makes something truly horrible constitutional. Right? And therefore takes away all that moral element that you've always associated with law. And if you want other great examples of this, you only have to look at the Constitution of Nazi Germany, drafted by Carl Schmitt, who was an evil legal genius, but a legal genius nevertheless. And, the Constitution of the United States of America, at the time it was drafted. Again, people like Madison and Franklin were geniuses, but they came up short on grounds of racism. Right? So, racism was legitimate in the United States in the 18th century. It was constitutional. Women were not allowed to vote. It was constitutional that women cannot vote. If you were, not a Jew, you could be picked up and killed by the state in Nazi Germany. It was constitutional. But after
slavery was legal in the United States.
Absolutely.
Slavery.
So all of these horrible things have been constitutional. So 21st Amendment, as citizens, as lawyers, as judges, forces us to confront that. And merely because we say something is constitutional does not mean that it's A, a desirable thing, B, good for our democracy, C, even good from an objective moral standpoint. So it's for you to decide whether military courts are good or not, regardless of the fact that it's constitutional or not. And there are other existing problems with the Pakistani constitution. For example, a non-Muslim can never be a head of state. We treat Ahmadis as second-class citizens. All of those things are constitutional, yet horribly repulsive to many people. Right. So, talking about how this is different from the Nuremberg situation, I think Nuremberg is misunderstood by a lot of people. What happened in Nuremberg was remarkable because there was no clear offense that the Nazi regime was being charged with. Genocide at that time was not an offense. The person who was chosen by the United States government to be the chief prosecutor at Nuremberg, Justice Jackson, started his career doing cow trials, in rural United States. And when he got to Nuremberg, he really had to scratch his head because genocide or mass massacre wasn't a crime recognized by international law. What he ended up prosecuting the Nazi regime for in Nuremberg was the crime of aggressive war. Right? And even that was not written down anywhere in any international legal court. Jackson argued that aggressive war is a crime that is recognized by all international countries, even though they've never written it down, that it's part of customary international law, that every country by its conduct has made clear that aggressive war is something, that is illegal, and therefore I am prosecuting these people for aggressive war. And his colleagues at the United States Supreme Court, especially the Chief Justice of that time, sent him letters mocking him. He wrote letters to him saying that, show trials that you're doing in Nuremberg are not going to bring you anything. Right? So at the time that they were carried out, Nuremberg wasn't a success. So I don't think that we should ever look up to Nuremberg as a model. They lacked legitimacy, they were not taken seriously by the lawyers, of eminence at that time. They only had one motive, which was public relations. You needed to be seen to be doing something, and you did it, and you were able to get away with it. That's all that Nuremberg has taught every state. You don't need to be seen to be fair, you don't need to be seen to be, doing the right thing. All you need to do when you have military courts is use it as a PR tactic. And if you can get away with it, it will be a success, and you can change the history later on and say it was a huge resounding success. If you cannot get away with it, then do not try it in the first place. Right? And I think that lesson is reflected in all international trials that we see in Rwanda, in Yugoslavia, even Saddam's trial. If you're able to get away with it, you will do fine. It's a PR tactic. Now, moving on to why did we need military courts in the first place? Again, I'll load 3 or 4 answers, and it's up to you whichever one you want to side with. One, there was a political necessity after the Peshawar attack, right? Because what has happened was truly horrible, and the government wanted to be seen to be doing something about it. So it wasn't as if Peshawar was the only thing that was there, but Peshawar changed everything. Right? It added something really horrific which we hadn't seen, in our war against terror. So the government wanted to be seen to be doing something. But there was also a military necessity. The argument is that the military committed a soft coup by incorporating the 21st Amendment into the Constitution. So there is also that argument. Right? And I think there is a lot to that because the military had been wanting to gain more and more control of how we fight this war. And Peshawar allowed the military to do that. Then there was the legal necessity. The legal necessity, it depends on how you see it. Was there a legal necessity in the first place? I don't know, because yes, we were trying to punish these people, but where we were coming up short or not, people blame the courts a lot, right? But I think the problem is essentially with witness protection. If you have a terrorist committing an offense anywhere in Pakistan, people will simply not show up to, give statements or to have evidence recorded. I think that's a big problem even in general murder cases. I'm not a criminal law expert, Saqi Saab is, but from what I've understood from a number of people, witness protection is a huge problem. So you don't have enough witnesses. Then there is also the quality of evidence that is available with the state. That was also lacking in many instances. So you've tried curing that in some other respects. You passed the Investigation of Fair Trial Act 2013, but you realize that that doesn't solve the entire problem. So that's why you created military courts. Now, how are these going to function? The answer that I'm going to put forward is that you don't need to set up separate military courts. Military courts already exist under the Pakistan Army Act 1952, right? And all you need to do is send cases to them and they will function. What is dangerous about the military courts is that the Army Act says that they can be established anywhere and the trial can take place anywhere. That is different from an ordinary criminal trial, because if you commit an ordinary crime, you're taken to the court of jurisdiction and your trial normally is conducted in the court that has jurisdiction over that area. In a military court, the trial can take place anywhere. So they can pick you up from Lahore and they can take you to, some remote part of KPK in a fort. The trial can start at midnight and finish by midnight, and you won't even live to tell about it. That's you using the I'm using the word you lose. So if you're in trouble, that sort of thing can happen. And you hear, multiple jokes about, I recently heard this joke in the High Court. There's somebody who works at the Attorney General's office and he was telling me that during Zia's time, there were these military courts functioning, not for terrorism but for other reasons. And so they were trying somebody and the lawyer was cross-examining the witness, and the judge, who was some army major who was heading the military court, said to the lawyer who was cross-examining the witness, he was like, can you hurry up? We also have to hang the guy. Right? So, that's how it's going to work. It's not funny. Right? And it's telling that people in Pakistan laugh at this. That in itself is depressing. It's not funny, but this is how things are going to happen. Right? So, if you read the Army Act, it says that normal rules of evidence will apply. Okay. So if you argue with an army lawyer and you say, well, there isn't going to be fair trial and due process, he will point that provision of the Army Act to you and he will say, look, we wrote it down in the law. Normal rules of evidence apply. The catch is that in an ordinary trial, when normal rules of evidence are not followed, you can appeal it before the High Court and the Supreme Court. By not providing a right of appeal, a military court does away with all those problems. So it can have you examined, cross-examined, re-examined within 45 minutes, can produce all the evidence, can have it marked, exhibited, and then ruled upon. But there is, since no appeal, you're basically done for. Okay. So that's another problem with the military courts. The next question, as citizens, why did we need military courts in the first place? Why did we amend the Constitution now? Because terrorism has been a problem, sectarian violence has been a problem in the past. Why have we never amended the Constitution? I'm sure, thinking people in this room and outside this room have asked themselves that question. Why are we amending the Constitution now? The reason are two Supreme Court judgments. One came in 1998 and the other came in 1999. In the first judgment, titled Meramali versus the State, Mr. Meramali was convicted of terrorist-related offences by anti-terrorism court set up under the Anti-Terrorism Act 1997. Right? The Supreme Court struck down those courts as illegal, saying that those courts are manned by people who've been appointed by the executive without the involvement of the judiciary. Okay. The Pakistani Constitution says in Article 202 and 203 that if you're setting up a court, you have to involve the Chief Justices of the High Court in the appointment procedure of that court. Right? So if you're setting up a trial, something at a trial court level, the Chief Justice of that relevant High Court has to be consulted that who are the judicial officers that we're appointing as judges to these trial courts. In Meramali that wasn't done, and therefore those anti-terrorism courts were declared illegal. A year later, and this was again during Mr. Nawaz Sharif's government, in the Liaquat Hussain case, the government brought out an ordinance which is presidential legislation. So an act of parliament is the normal legislation that we have it goes through the two houses except for the money bill, and the ordinance is the legislation, temporary legislation that president passes for 120 days. In the year 1998, the president passed an ordinance titled the Military Courts Ordinance, and they set up military courts, right? Those were to be manned by military men. And the Supreme Court struck that down as well, citing Article 175, which was pointed out by Mr. Saqi and Ali. Ali and Mr. Saqi, as they pointed out, 175 was cited by the Supreme Court when striking down the Military Courts Ordinance 1998, and they also relied on 202, 203, which I've already cited, that when you're setting up a trial court, involves the Chief Justice of the High Court, because the judiciary must have control over the judges that are appointed. That wasn't done in 98 twice, and the Supreme Court struck that down. Those were ordinary laws. Right? So now we have a pretty smart Attorney General in office. And it's a very well equipped Attorney General's office. Some of the best lawyers that I know right now work for the Attorney General's office. So those guys knew sitting there that those two Supreme Court judgments are going to get in our way if we do this the ordinary way. So they went up to the government and they said the only way of going about this is to amend the Constitution itself. And will the Supreme Court strike down a constitutional amendment? We're not going to bet on that, but we can tell you as lawyers and as good lawyers that they've never done it in the past, that they've never gone there. So we are giving you your best possible bet. You want to try these people? You want to hang them speedily? Hang them speedily. The only objection that people like Waqqas and the slums crowd will have is they'll raise their hand and they say, hey, that's unconstitutional. And we'll change the Constitution and we'll say, you said it's unconstitutional, now it's constitutional. So what's your problem with it now? And then you say, no, but actually there is a basic structure to the Constitution, so even something constitutional can be unconstitutional if I judge it against a basic structure. And they would say, you can try your luck in the Supreme Court, but they've never done that in the past. And they've never struck down any action sponsored by the military which is dealing with the national security problem. So if you're a human rights defender, they're saying, we're calling your bluff, go try your luck.
Including military coups.
Yeah, absolutely. Including military coups. No military coup has ever been declared illegal except the last attempt by Musharraf. Right? So you have history stacked against you. And throughout the world, this happens even in the United States. When government lawyers come up and say that this is a national security problem and the military is also with us on this, courts, even in the United States, have often said this is a national security problem, we're not going to touch this. This happened in 1945 in the Korematsu cases when the US, detained, interned Americans of Japanese descent. It has happened even in many Gitmo cases as well. When you cite national security, courts tend to take a step back and say, we're not the experts in this. They love ridiculing and kicking down politicians, but when it comes to matters of national security, it's more difficult. Right?
Sounds familiar.
So in a country like Pakistan where you already have a civil-military imbalance, this becomes a really, really difficult task. And it's also difficult to challenge this in the Supreme Court now and then be seen as a Democrat. Because if you successfully challenge the 21st Amendment and you win the case, then the politicians in Parliament are going to come up to you and say to you, what have you done? You've basically taken away whatever we did, even if it was right or wrong, and you've given this enormous power to judges, that in future, whatever we do with the Constitution, they can tell us that you cannot do this. And a parliamentarian is going to say, the only, thing, you dummy, that was protected, from interference by the judiciary was the Constitution. That they have never before in the past told us that this is not how you amend the Constitution. We've always gotten away with that. And now you've also taken that away from me. So it depends on which side you're on. If you're trying to be a Democrat, then probably I think the better answer is what Ali proposed here. See it as something truly horrible, but say that this is a stopgap measure and I'm not going to mess with it. Yes, it does not sit well with your sense of human rights, but if you give this power to the courts, or if the courts, and trust me, the courts would love to assume this power.
Yeah.
They're not going to be reluctant about it. So if you give them this power that now you can even tell us how the Constitution can or cannot be amended, you will have a lot to answer for future generations. So it's a really difficult exercise that we're in. Right? And the last thing that I wanted to talk about is the point that Ali validly raised, but I just have a different take on it, so I'm going to share it, that yes, we can say that this is what the Constitution says, and as a literalist and a strict constructionist, that is the end of the matter. But the US Constitution never provided that the US Supreme Court can actually strike down congressional legislation. Right? They came up with it. So all Supreme Courts in the world will come up with ways of interpreting documents. So they do, and I'm not saying that judges are evil or they're bad people or anything like that. Please don't think that I'm saying anything of that, hue or color. I think this is a genuinely difficult thing to deal with. I mean, as humans, we are all, most of us, are ambitious people, especially when we're in positions of power. We all have our own visions of what direction a country should take. And when we have the chance to make history, very few people have the ability to step back and say, I'm not going to exercise this enormous power that I can exercise. Right? So don't see people as good or bad or evil or not evil. These are individuals like you and me, 30, 40 years down the line, who've thought about difficult problems in their fields for 20, 30, 40 years. They're now at the peak of their powers, and now they're faced with some of the most difficult questions that any judge or any politician in any country can ever be faced with. Right? So that's how we have to view it. One last thing is that even if we see it as a stopgap measure, I respectfully disagree with Ali and everyone else. Lots of people say it's a sunset clause and after 2 years everything goes. Right? But the lawyers here, any law students or even otherwise, I'd ask you to read Article 264 of the Constitution, that is 264. Right? Article 264 says that where any law is repealed by the Constitution, as long as you have started action under that law, you can take it to its logical conclusion. That's what it says in simple terms. So all that the Pakistan Army needs to do in these 2 years is charge enough people. It doesn't have to hang them, it doesn't have to, sentence them. It needs to charge thousands of people. And even after 2 years, those things will continue. Right? And the very last thing, again the voice of cynicism here. I don't know if military courts are even the real problem. Because wherever you've seen, insurrections and rebellions and wars related to terrorism, the military does not bring the most difficult cases before military courts. Those killings still happen in dark rooms in an extrajudicial manner where a firing squad picks up 40, 50 people, blows them to smithereens in the middle of the night and you never hear about it. That's where still most of the violence is going to occur. It's not going to occur in the military courts. This is just a PR tactic. A Baloch may not be covered by this, but a Baloch will be picked up and riddled to bits still. Right? People that the army and the establishment want to get rid of, otherwise they're not going to be brought before the military courts. You will probably get, if you have 10 top terrorists, like the US had that deck of cards, if you had 10 top terrorists, you'd probably get 1 or 2 of them before the military courts and have a largely secret show trial and then the announcement of the verdict. But the rest of the killing, the bulk of the war, isn't going to be fought before the courts. This is just a PR tactic. That look, we're doing this the legal way. But that's not, what the real issue is. So if you're a human rights defender or interested in human rights, the real problem in Pakistan was, is, and will be, for our lifetime, the civil-military imbalance. So the military courts do not really change anything. They just add gloss and provide a handful of examples that we can all get agitated about. But the real war is still taking place elsewhere, and it has been and it will. Thank you.
You have a few fans here. Thank you, Waqqas. Very nice presentation. A number of points thrown up, which I'll very briefly refer to, and then throw the floor open for questions or comments. My only request is, please keep it brief. You're not a panelist. Please ask brief questions and brief comments. Nuremberg trials and other such trials that you mentioned sounded to me like what you were arguing was this is victor's justice. This is not justice, it's victor's justice. The winning side makes its own rules and its own laws almost, as it were, and then it proceeds to implement them without reference to any great principles or universal principles. I take on board the point that I think the ABS massacre in Peshawar did produce a critical mass of opinions. You know, there are these conjunctures in history, time, a moment when something just maybe festering under the surface but then gels suddenly and becomes something effective. Yes, I take that on board. You spoke about witness protection being a problem. Prosecution is a problem. I mean, the weaknesses of our prosecution system, quite apart from witness protection. My fear also is that the Thana culture believes in karwai. You know what karwai is? Going through the motions. My fear is that, you know, if somebody finds it convenient to pick me up and shove me into a military court under a terrorism charge, even though I'm not guilty, somebody has it in for me. Miscarriages of justice are floating on the surface of this whole business. This is my apprehension. I think as far as the government is concerned, it seems to have, on the basis of the experience of the 21st Amendment, which I think it has misread, come to the conclusion that amendments can be passed in this manner all the time, you know, without precedent. So the 22nd Amendment can be passed within our days, you know, bring about a show of hands in the Senate election. I mean, it's absurd. Anyway, that's just a light comment. You spoke about the danger of giving judges that kind of power to overrule Parliament, democratic people's will, so to speak. But you know, our history is replete with constitutional amendments which could not be struck down, according to your arguments and these arguments, and yet are appalling. There's the Second Amendment, which declared the Ahmadis non-Muslims. Now, what has Parliament got to do with, you know, declaring someone a Muslim or non-Muslim has escaped me. Maybe I just think, I don't know. What about the Eighth Amendment, which alters your constitution literally from top to bottom? And to this day, despite the 18th Amendment, you haven't been able to get rid of all of that. Most of it you got rid of. But a lot of important things are still lingering there. So our civilian elected governments, our military governments, think nothing of tinkering with the constitution and making a mess of it. And there's no check. If you're saying constitutional amendments can't be challenged legally under our constitution, then we're done for. I mean, they can literally, my apprehension is they can literally do anything, and then we're in trouble. Our politicians are not known for wisdom, nor are our military regimes. So, you know, there's a danger there. Very interesting point you made about the sunset clause. Sounds like a continuing sun. No sunset.
Yeah.
So if you pack the provision with enough cases that will go on and on and on, you could be riding off into the sunset rather than the sunset clause. You know. Very good point you made about military courts probably ending up as the tip of the iceberg. The real operations that are hidden from view, whether in FATA or in Balochistan. Now the problem is, you know, I as a media person can tell you we don't have access. And every time I complain to my friends in the military, why don't you give us access to the operation? Surely it will help you. All they are prepared to do is give me a guided tour. So we've heard the word embedded journalism. I'm not a great fan of embedded journalism. So I've refused. But my point is that I do get information from Balochistan, from FATA, this operation that's going on, operations that way, without meaning to sound, you know, subversive or unpatriotic. I think things are being done in this country by the military and security forces that will make your hackles rise. The way people are being tortured and killed and dumped defies description. And there's a complete cloak of impunity over it. Even our all-powerful Chief Justice Iftikhar Muhammad Chaudhry's Supreme Court tried its utmost to penetrate this cloak of impunity was unable to on the question of missing persons. Disappearances, extrajudicial torture killings. You know, my friend Senator Faratullah Babar has just introduced a bill in the Senate against torture. Wonderful. I hope it passes in the National Assembly. The thing is that Pakistan has a history. It's not a very shining example of democracy, law and human rights. It's the opposite. And some things were set in motion very early in our history which persist to this day and are almost permanent facts of life. And one of them is the citizen is not safe. His rights are not safe. I use is in a generic sense, please, no offense. So I really have a lot of reservations and questions, and I'm conflicted by many things that you have said. I'm enlightened and educated by them, but not necessarily always persuaded. I'm throwing it open. Anybody have questions? Sir.
Yeah, so my question is for Ali. You talked about the necessity, the military courts being necessary because of the failure of the criminal justice system. So there are two issues here. One is the crumbling of criminal justice system is the main hindrance in our fight against terrorism. Has there been any study for that? And the second issue is, what is the failure? It is the failure of providing the justice. If it is the failure of justice, then I fail to understand how judges who are major will overcome that problem. And if it's a problem of failure of security, then it's related to the first issue, that the real problem lies somewhere else rather than in the criminal justice system. And it could probably be addressed through other means, by providing security to the regular courts instead of just popping up a whole new system and sidelining the regular courts. The second question is about the power of the courts to strike down constitutional amendments. Being a staunch Democrat, I will hate to see any court ever striking down any constitutional amendment. But is it possible for courts to give an observation that two clauses of Constitution are probably conflicting, or make an observation like some constitutional clause is against fundamental human rights, as written down in some other clauses of the Constitution itself? Just an observation.
Okay. I'm going to start from your third question and then work myself back, okay? And I'm going to clarify some of the things that I said, which was subsequently raised by Waqqas as well in his talk. Okay, the third thing that you said is to do with constitutional amendments and how, you know, as I held the line, I see it as anti-democratic. You've got to understand the difference between an ordinary statute and a constitutional amendment. Whereas an ordinary statute, I'm fine with judicial review of ordinary statutes. But for an amendment, there is a special procedure. You need a two-thirds majority, for example, to pass an amendment. That special procedure is what distinguishes it from an ordinary statute. So I'm fine, for example, Marbury versus Madison, which Waqqas raised, has got nothing to do with constitutional amendments. It's unthinkable for the American Supreme Court. Even Justice Black, you know, even for him it would be unthinkable to strike down a constitutional amendment. That fundamentally goes against democratic principle, the majoritarian democratic principle. Now understand, now there are two ways of looking at the democratic principle. There is the majoritarian Athenian principle, and there is the Republican Roman principles that you know are also there, and those are the ones that actually govern modern systems. Modern constitutions are based on Roman Republican principles rather than the pure majoritarian principles of Athens. And you need institutions like the Supreme Court to act as counter-majoritarian institutions in some cases, right? But am I comfortable giving a court of unelected people, especially here in Pakistan? Again, the American context is slightly different. The democratic setup has more of a say in who becomes a judge and who doesn't become a judge in the US rather than here in Pakistan, right? So I
tried that and it failed.
So,
sure.
my question was a little different. So I agree with your point on this. I'm just saying, are there examples where the courts can just issue an observation? They can make an observation that these two clauses are contradictory.
Well, we have what's called harmonious construction, right? I mean, there are inconsistencies in our constitution which have been, I think, documented in certain cases. Waqqas can sort of corroborate me on that. Okay.
Maybe if I've understood the question correctly, I think perhaps what the question means, and correct me if I'm wrong, is would such a recommendation, if it came from a court, act like a recommendation to Parliament to review what it has done? I think that's
what I
meant.
Supreme Court has only declaratory jurisdiction to declare something constitutional otherwise, or like a recommendation.
They're not legally bound by it. I think that's what Prakash Chaudhary tried to do with the 18th Amendment case. He sent it back to the Parliament, right? And that's where this entire mess.
मर्जी की बहस में लगवा लिए और उसको उधर भेज दिया.
So I think that's what we have to
bargain
do,
chip.
right? Now your first question is very interesting. Is this the panacea to countering the scourge of terrorism in Pakistan and military? Absolutely not. We should never be deluded by that. It's not even the tip of the iceberg if you even want to consider it that, right? This is a fundamental and a much deeper problem that we have in our society, and there are many different ways of, sort of countering it. My suggestion, and for me, the most important sort of thing that needs to be done is that you need to revise your syllabi. You need to sort of perhaps revise the syllabi of the madrasas.
Yes.
You need to change the mindset. Rather than
counter narrative.
Create a counter narrative. Does the state have any narrative against the TTP yet? It never has had any effective counter narrative so far, right? So I agree, these are all cosmetic measures, right? But since they've been instituted and since we were having a legal discussion, I chose just to focus on the legal aspects of the problem rather than dealing with with the hydra-headed monster of terrorism, right? What was your second question? Sorry, I've forgotten your...
So my second was that given the failure of the criminal justice...
Okay, I remember.
The failure of security.
Well, it's a failure at multiple levels. So there's a problem with police, there's a problem with police investigation, there's a problem with prosecution, and there's a problem with the judiciary as well, and the lawyers as well. I'm going to criticize the legal community as well. So all of them are essential building blocks of your criminal justice system, and you need to fix all of them if you want to bring any meaningful reform to the system. Now, the military courts, one advantage that they have is that they can have in-camera proceedings. Now, I know those are offensive as far as due process guarantees under a normal human rights regime would compel us to follow. But that gives, they definitely have a security advantage when it comes to them. And as Waqqas also pointed out in his presentation, one of the major issues is witness protection that we have in this country. There have been attempts. I know Sindh passed a Witness Protection Act, I think a year ago or something. But if you read, it's a little impractical. They've just borrowed everything from the US. In the US, it's very easy to relocate witness from one jurisdiction to another. They've got very strong patrimonial kinship ties. It's a different culture. It's a different setup. It's very hard to get away from your society here. So we need creative thinking. And yes, as Waqqas, I'm glad he clarified that. Sunset clause does not mean that after 2 years the whole shop is just going to close. It just means that after that point no new cases can be referred to it, but the existing ones will go. And as I sort of emphasized repeatedly in my presentation, I do not want to see them as exercising an expansive jurisdictional scope. I want to see them restricted in, for example, like Gitmo trials, or when the US couldn't even try more than 2 or 3 people in Iraq. They set up military tribunals in Iraq as well to try non-state actors, in Afghanistan as well. So there are inherent issues embedded with that. And the last thing, since Waqqas mentioned that, the Nuremberg trials, I agree with him. And what I was trying to say in my presentation was that since Nuremberg accepted the principle of retrospectivity, I do not want these courts to actually accept that reason. So Nuremberg is a dark scar as far as, global jurisprudence is concerned. It should not be seen as a shining example of something that worked effectively and replicated all over. In any case, at the international level, the trend now is not for national countries to have their own military courts. Now the trend is to take the matters to the International Criminal Court. So there's been a lot of jurisprudence which has evolved since the Nuremberg and the Tokyo trial days. So we need to keep that in mind as well. Okay.
I just had a horrible thought. What if the sunset clause is extended 2 years from now?
They can do that. I mean, there's always a possibility.
Yes, sir.
I'm sure.
I have a question. Professor Waqqas Mir.
Not a professor. You are a professor. Today you are titled. Sorry.
The discussion of 21st Amendment has also brought forth this dichotomy between the due process model and the other which we call the crime control model. So do you think both of these can be sort of incorporated? And why are we talking about these in terms of dichotomies?
I think that's a great question. I'm not sure I have the answer. If I did, I'd be very rich. The government would pay me a lot of money. I think the answer depends on where you stand on the issue. So if you're a conservative, you interpret the words due process very differently. A liberal sees due process as something that is fair, inherently fair. A conservative sees due process as something that due process is the process prescribed by law. So whatever you write into the legal document, that is the due process. It's not a higher guarantee. Right? So if you're a conservative, the immediate answer is yes, of course, the due process and crime control model are, there's nothing contradictory about them, because due process is the process given by law, no matter how unfair it may seem to you. If you're a liberal, then the answer is more difficult. And again, it depends on how you read the Constitution, as a living, breathing document or as an enduring document which has certain set meaning. And again, I won't give you an answer what I think, because I think that's for everyone to figure out on their own. But I think there is a tension, there is a serious tension. And the answer isn't as easy as a conservative saying, of course there's no problem.
Yes.
I suppose this question is addressed to the entire panel. With the introduction of Article 63A into the Constitution, I believe what essentially happened was that party leaders or political parties in general gained a veto as far as constitutional amendments were concerned, especially in matters of national security, in the sense that if a party leader was to say that security matters constitutional amendments need to be voted for in a certain way, that parliamentarians can't floor cross. So this was a provision introduced against horse trading, I believe. And the context of the 21st Amendment kind of highlighted this notion that parliamentarians can't necessarily vote their conscience anymore, because, as Rashed Rahman said, it troubles him to not be able to vote against it because he can't. His hands and feet are tied. So do you feel that the Article 63A and the 21st Amendment kind of create this, put the decision of making constitutional amendments, which should otherwise be a very difficult process? In the United States, I believe, you require all the states to ratify constitutional amendments. It's a process that takes several years. It's in the hands of maybe 2 or 3 people, essentially.
Good question. Anybody?
Article 63 confines the discipline of the political, people, of the leadership's orders. I think of money and budget matters and the voting. We can read that. I think there's the two compulsions provided in Article 63A, whereby the defection can be conceived in that way, that he may be declared in writing by party head so and so, resigns from membership of the political party and joins another parliamentary party. One thing, votes or abstains from voting in the House contrary to any direction issued by the parliamentary party to which he belongs in relation to election of the Prime Minister or Chief Minister, or a vote of confidence or a vote of no confidence, or a money bill or a constitution amendment bill. There are 3-4 things which have to be followed by the members of the parliamentary party, whatever their leader says. And beyond that 4 provisions or 4 eventualities, they are free to do anything.
These 4 provisions, I think that's the question.
Yes.
Let's discuss it.
But this
It does subvert freedom of conscience. I mean, if I don't agree with my party, but I can't because of these provisions, 4 provisions, 63A, vote against my party. In a sense, I'm in a straight
Then one has to resign if he doesn't follow the party discipline. Then obviously, otherwise we'll go horse trading and bargaining and changa manga and this. You know, this history we have.
21वीं तरमीम में तो कोई ऐसी
यार ये तो फौज ने किया करवाया सारा कुछ इसमें तो और इशू नहीं मैंने पहले अर्ज कर दिया कि इसमें कोई ऐसी एप्लीकेशन ऑफ माइंड वाज नॉट देयर टू बी कंसीडर्ड इन एनी वे.
There are only changas at this moment.
Not manga.
Yes, gentlemen. You.
So I'm not a law major and I'm more interested in the political implications of the amendment. So my question for the whole panel is that what could be the possible reason for limiting the scope of the amendment to just religious, terrorism that was being, that had religious motives and not expanding it to political motives and all that? I mean, why didn't the men in boots actually want to include that? That would have actually allowed the army to, you know, it would have been desirable to just, that would have legitimized the operations in Balochistan, you know.
And Karachi.
Yeah, and Karachi as well. So why do you think that they limited the scope of this to just religious parties?
If I was on the panel, I'd answer that.
Do you want to go ahead? Please.
I'd love to hear that.
Go ahead.
We'll have to hear you, sir.
Okay, I think that's a very good question. But I think deep down, the army really wanted to target the Tehreek-e-Taliban Pakistan and their affiliates through this amendment, and not other classes of terrorists that you can come up with in Pakistan. And there are many, right? There's the Karachi problem, and there are problems in other parts of the country as well, so on and so forth. The other interesting thing is that I think we as a state need to be certain now that we cannot pick a good militant and a bad militant now. I think that's very important. I think this is the distinction that we've tried to draw for various reasons. It could be geopolitical, it could be strategic, foreign affairs related, so on and so forth. I think everybody in this room knows what I'm talking about. But I think this, if you really want to, and this is an answer to your question as well, if you do want to effectively counter the menace of terror that we're facing right now, you will have to adopt an approach that targets all shades of militants belonging to the Tehreek-e-Taliban Pakistan and their affiliates. And keep it restricted, don't unspool it, because then the whole thing will become too unmanageable. And we'll end up with the same problem that we today see with the anti-terrorism codes, with thousands of cases clogged for decades now.
And they don't want to perish that sort of people because they need them after some time.
Plus, I think it's, it's easier to sell. You want something done in a hurry. You're going to politicians and you're going to say, pass a constitutional amendment, and if you write it down, this covers politicians as well, they're not going to vote for it. You know, they're going to push back, it's going to take long. So it's easier to sell. Say it's about sect and, religion, and we're in a war. And the only guarantee they wanted was this doesn't cover politicians. So there you have it. Just think of it from a marketing point of view. You want quick votes, what do? You go to the person who can give you what you want, and it doesn't do him any harm. So.
Let me just add, if I may, although I'm not, as I said, on the panel. Since 9/11, every movement that challenges a state in some way or the other by force of arms has been lumped into the terrorist basket. There was a time when that was not the case, and the argument revolved around one man's terrorist is another man's freedom fighter. That distinction has been obliterated since 9/11. Everybody's a terrorist who has a gun that challenges the monopoly of violence that states adopt for themselves. Okay? whether the cause is just or unjust has been thrown out the window. There were insurgencies, armed struggles, guerrilla struggles in the past that were considered just, heroic, and were supported. Today, try doing that, and you will find Washington and a few other countries in the world coming down on your head like a ton of bricks. With the exception, of course, when they intervene themselves and create the very terrorists they say they are against. Take Libya, the whole of North Africa is destabilized because of that intervention.
Yes.
Take Syria, Iraq, the whole Middle East is destabilized. The vacuum they have created has given rise to IS, even more terrible than Al-Qaeda and all the others that came before. So, this is, I'm sorry to say, there's no high principle floating around here. It is expedient, geopolitics, and interests that dictate these things. Every state has it and pursues those, and it doesn't matter if somebody else's interests get trampled on the way. The Kashmiri struggle, just to give you an example. I remember soon after 9/11, the Americans had not yet invaded Afghanistan. There was about a 7-week hiatus. And we editors were invited to a lunch at the Foreign Office, very rare occasion anyway. And I remember the Foreign Secretary, Mr. Inamul Haq, to whom I had the temerity to suggest that I think Pakistan should revisit its Kashmir policy. After all, since '89 we have been supporting an insurgency there. That very soon now the trend was obvious to me that the Kashmiri struggle and all such struggles would be lumped in the terrorist basket. And Pakistan would find it difficult to continue this support. He flew into a rage with me. I mean, short of, gali galoch, he did everything else. Unpatriotic, this, that. I said, I'm not saying anything, I'm just suggesting a possibility and that perhaps you should consider this. He was apoplectic. I couldn't understand this. And I talked to colleagues later and they said, look, there is a narrow, fixed, rigid mindset here. I mean, Kashmir is a red rag to the bull here. That's what you've done. But the fact is, I'm coming back to what I was trying to say. The reason why it happened the way it did, to return to your question, 21st Amendment, is I think partly what our friends here have said, but partly also because of the resistance by certain political parties to allowing this chink to become an open door. On the one hand, there were parties like MQM, which didn't want this kind of door open because it has implications for their people in Karachi. As it is, they're complaining every day about their people being killed and extrajudicially and so on and so forth. Then there was resistance by parties that are sensitive to the Balochistan situation, that they would be lumped into this 21st Amendment basket. And then of course there are political parties like the PPP, which has long experience of being pulverized for dissidents. So political dissidents too didn't want to open this door more than a chink for the religiously based terrorism and sectarian based terrorism which defines TTP and its affiliates, and full stop.
Sir, I was looking over some cases, anti-terrorism cases in 2003-2004, which were tried under the ATA 97. And I could not find any reported judgments or any reported cases in which someone had actually tried someone for an act of terrorism, an actual act of terrorism. There was assault, there was a lot of things like that, but there was no terrorism. Although there were like 2 attacks on the president in that time period, but no one was tried for that, no one could be convicted or taken to a higher court for such an act. So my question is, even if we have military courts and even if the sunset clause works and the time lapses in 2 years and after that we go back to our anti-terrorism laws or whatever, do you think that without solidifying our prosecution and without solidifying our police and investigative agencies, is there any way in which we can try criminals and terrorists in the long run, even after this 2 years period or however long this continues has lapsed?
I have the short answer. If you'd like to give a long answer, sure.
Okay, I think you again raised an excellent point, and it's something that I alluded to in my presentation as well. One of the necessities that we see with the military courts today is this backlog of cases that we have in the anti-terrorism courts. And the reason why we have this backlog of cases is precisely because of what you just pointed out. It's got all kinds of cases, including cattle theft. Gai chori ho gayi thi mere gaon mein. I can bribe the IO, and he's going to register the case under the ATA because the punishment saft hoti hai. There's no.
It's become a convenience, right?
Right. It's become a matter of convenience for police. Yeah, exactly. So the system is massively abused, and so yes, we need to sort of fix the investigation, the prosecution, but also the judges. We need jurisprudence developed on this point. What is terrorism? How do you define it? How is it defined in the Anti-Terrorism Act? As far as I understand, I think Justice Khosa was the only one who was sort of fighting this lone struggle in the last 10 years about trying to define terrorism both in terms of the Act, which is how it's perceived in Pakistan. If the Act is ferocious, the terrorism ho gaya. I once met an SHO, and I was just interviewing him, and he goes, "Sir, मैं आपको एक चीज़ बताता हूँ, अगर एक गोली चले तो हम ordinary, criminal CRPC का पर्चा हम दर्ज करते हैं, अगर दो गोलियाँ चल जाएं, anti-terrorism court का सीधा हो जाएगा." This is the thinking, this is the mindset that we're up against, that we need to change here, right? And the judges, yes, they need to develop the right jurisprudence. You need to extend what Justice Khosa was suggesting in some of his judgments, which the other judges did not go along with. Okay? And he laid a lot of import on the element of mens rea, or the intent. Terrorism, you have to have a certain mens rea to commit an act of terrorism which differentiates it from an ordinary crime. That appreciation, and that's where I really blame the judges here as well. If they wanted, they could have interpreted the ATA very narrowly from the beginning, and we wouldn't have this problem today that we do.
I mean, it distinguishes it even from premeditated murder. Premeditated murder and terrorism are two different things.
I mean, intent. Oscar Pistorius got off on the mens rea element, so that should tell you how important this inquiry is in developed judicial systems. So we need to replicate that.
So I have a question right over here, and it's hard to see on this side. So good points, and Waqqas, I wanted to build off one of your comments. You were saying that potentially you could see the expansion beyond the 2 years. And I think that if we look at sort of, because the discourse has been dominated by America and sort of the jurisprudential traditions that have come from the United States, if we look at what the United States did with the Military Commission Act in 2006, and then its subsequent appeal in 2009, and then its basically establishment as de facto law governing Gitmo and anti-terrorism cases, can't we see this then being replicated here in Pakistan, in the sense that when as states, I'm a political scientist, and when we study states, what do we see? States, once they are given power, they're very reluctant to give it up. And so when you're given this thing, yes, you have sunset costs. Yes, potentially we could see this further developed. But wouldn't this lead to the further militarization of the Pakistani state and sort of the delegitimization that we actually believe in this country in democracy? And that in its essence, this is extremely anti-democratic, and that even when Ellie was saying that, oh, well, this is the least bad option, is this the least bad option? I think it could get even worse, because if we go down that path, it is a slippery slope. And if we're holding America as some sort of paragon of justice and freedom, why is it that they have the most individuals incarcerated behind bars than any other country in the world, right? Or that its entire system has been basically upended because of 9/11 and this concept of terrorism.
I get glad on you.
Thank you for raising some excellent points. So I think, yes, there is the danger that, after 2 years it will not and it will continue. I think the only certainty right now is, as things stand today, and it can change tomorrow, is that this constitutional amendment lapses automatically after 2 years. And then what happens after the 2 years, I think that depends on, who's in power then, whether the military is in power or, we have politicians in power. If we have politicians in power, I think the military will still want to do something through the constitution. Because now we're in an interesting phase of Pakistani history where the military, I think, is more skeptical of politicians and the judiciary than they've ever been in the past. So the reason that the military wanted the constitution amended is because I think they knew that if they tried doing this through an ordinary law, they didn't trust the Supreme Court. Earlier you've had a very pliant judiciary in Pakistan. Right now they said this could go this way or that way, and if it goes against us, the boys in uniform thought it would be too embarrassing. So we have a more independent judiciary that can stand up, and we have politicians who are increasingly assertive. This isn't a particularly good example of what I'm saying, but I think that there will be more and more pushback. So they will want to do something through the constitution, but yes, it is a slippery slope that we're in, and I think things will get worse. And if they can't do it through the law, then yes, the extrajudicial measures become much, much worse. And the access that Mr. Rahman spoke of, that becomes very, very limited. Yeah.
Let me just add that militarization, yes, certainly of state and society. But I think it's interesting to note that the world over, the few exceptions notwithstanding, military coups are not the flavor of the month anymore. It's becoming more and more difficult to get away with military coups. Pakistan has a whole history of them, we all know. But I think even in Pakistan's case too, for reasons that are lengthy of explanation, briefly let me just say that there are, let's say, a huge gulf of differences between us and Washington. And therefore, without Washington's nod, it's unlikely the military will take over and will continue, which is in some ways convenient, to operate from behind the scenes and push the politicians around. Yes.
Yes, I had a question. I was very surprised and astonished to hear both Ali and Waqqas criticize the Nuremberg trial. And it seems to me that you have clearly a very legalistic perspective on the Nuremberg trial, but actually exceedingly narrow legalistic perspective. Because you say, okay, so there was retrospectivity and there was victor's justice, etc. Okay, I mean, in strict legal terms, perhaps there were some flaws, etc. But what matters, it's not the only thing that matters in a trial. It's also, in the case of Nuremberg trial, it was also a political, moral, and symbolic case that was made. And in particular, the case that now, the possibility of crimes against humanity, that a crime is not just something that is, that affects the relatives, the direct relatives, or even the nation state, etc., but it's something that affects us all because something was done to the Jews, which is not only about the Jews, which is about what sort of humanity we want, etc., which is the same argument against slavery. It's not just the slaves who suffered to be slaves, we suffered. So it seems to me that by saying, oh, but it was like legally, it wasn't, and Justice Jackson wasn't really cool, etc., it seems to me that you're missing the whole, the turning point that Nuremberg, that Nuremberg represented, and in particular the issue of universal jurisdiction, that we now say, for there are some crimes which are morally, politically, and even legally more important than just and this is what was, you see, it's like I'm very surprised to hear that, no, Nuremberg.
Well, okay, I think that's a fair concern, but you also addressed where Waqqas and I were both coming from. I think we were both looking at it, if I can speak right, we were both coming from a strict legal lens. We were just, we were analyzing the legal aspects of it, right? But if you look at the Nuremberg trials and assess it from a moral or a political dimension, of course, you could make a very compelling case that it did serve a very useful purpose in terms of at least blaming someone for the atrocities that were committed in World War II, and also for setting the stage for further universal jurisdiction as well as further military tribunals that we see today in Rwanda and Sierra Leone, Yugoslavia, as well as the ICC. It really is a forerunner to all of these developments. So, of course, it has that place.
It's a turning point. But what has followed is an imperfect work in progress, in my view, for the simple reason that many people can still get away with atrocities, like General Pinochet of Chile, and others. So it's a work in progress.
Because of the weakness of universal jurisdiction, not because of, you see, it's because we don't have enough of universal jurisdiction.
No, that's what I'm saying.
So as long as we cling to our nation
That's why I
state,
call it imperfect work in progress. Okay? This is the way direction we are going in, but we're still along the way, not yet there.
Yeah. Well, I just like to clarify. I apologize if I came across as, being critical of Nuremberg. I wasn't being critical. My point was, in fact, the point that you're making, that law doesn't matter. When you're doing a trial such as this, law doesn't matter. What Justice Jackson was doing was lousy law, and his own Chief Justice was telling him that you're not doing law. What he was doing was politics. And if you, have the politics with you, then it really doesn't matter. So, I mean, and then I think that the danger is, but, I mean, Nuremberg did some fantastic things, you're absolutely right, for the point of view of universal jurisdiction. But Nuremberg shouldn't make us all advocates of consequence-based reasoning. That let's look at what this eventually achieves and we'll decide whether this was a good thing or not. Because when you're trying people who are accused of certain offences, as you are in this state, as we are in Pakistan right now, the lawyers for those people will say they have certain fundamental rights. So don't apply consequence-based reasoning. But as far as Nuremberg is concerned, I'm a fan, of what it achieved and what it did for global justice, and I think it did great things. But as a lawyer, even the school, that I attended in the US, we're taught it as a case where it stood for something much bigger later on than it was at the time that, it took place. So the law wasn't really relevant. So I was trying to see it from a legal perspective. And my point is that the law fades into the background, because even here you have the real political power vests with the army. So if we become too legalistic about what's wrong and what's right with the process of military courts, we miss the actual picture about what the military is actually doing. And same with Nuremberg. If we get too embroiled with the law, we miss the larger point that was at play, which was global justice. And here it's civil-military balance.
You guys have just raised a very ticklish question. The relationship between law and politics and the dialectic between the two.
All law is politics. All law is politics.
So do we have time, Amnesty? Do we have time?
Yes.
Yes.
Slightly a very simplistic question, but you were talking about the civil-military ratio and how it needs to be improved. How is it going to be improved? Anyone?
Let's wait and see.
Civil-military imbalances as the genesis of the country has to be seen in the perspective that Mr. Jinnah opted to become a Governor General and Nehru simultaneously opted to become a Prime Minister. You can start from your democratic journey from the founding father, that what great deed Mr. Jinnah has done in the shaping of the future of this country. So we are suffering from that moment till today. And this is the history and genesis of the civil-military imbalance of this country. And God forbids, what happens I can't foresee. Thank you very much.
Anybody else?
There's one more question.
Yes, but he's had one already. Okay, for lack of a better question. Go ahead.
So, from a political perspective, I'm a bit confused about this whole exercise. Did the military really needed this law for the fight against terrorism? Why did they push for this thing so hard? This push makes the whole thing very suspect.
Well, I think the reason is, again, it's public relationing. You couldn't have gone to the families of victims in Peshawar and said, we're going to be killing all these people in dark dungeons and cutting off their limbs, and you can't sell that idea in terms of justice. You had to go to people and said the people who did this will be brought to justice, and we'll take them to task. And the way you do that is you have a court, and the best way of handing down justice is control the court that you have. So that fulfills your idea of justice. Maybe I'm being cynical, but as Abid Saqi said, all law is politics, so I find something political in everything legal. I think they knew that they could control the court, so they could sell it as a PR strategy.
So veneer of justification.
That's all these military courts are. I mean, I hope anybody doesn't think this is going to bring us real justice, if there is such.
Thank you very much. There are smokers on this panel who are having withdrawal bangs, including me. Thank you very much. You've been a very attentive audience. Thanks my panel. It's been really excellent. I think I've learned quite a few things tonight. I hope you have too. Thank you very much.